Hi, I'm Tom Rosch, and I'm a commissioner at the Federal Trade Commission, and I should also add a longtime friend and admirer of Michael Brockmeyer, and it's a great pleasure to be here today to talk with him about his background and experiences in antitrust. Michael, let's start with the vital statistics. Where were you born and when, and if you can kind of bring us up to date, just in the broadest fashion.
Well, sure, and Tom, before I answer that question, I also want to thank you very much for taking the time. It is really an honor for me to have you do this interview with me. And I was born in May 1952 in Baltimore. My family has been in Baltimore since the early 19th century, and lived in Baltimore my entire life, except for a period when I went to Arizona State University. And
let me just ask you, how'd you happen to go to Arizona State?
Well, I went
up in Baltimore.
I went to a Catholic boys' school in Baltimore, and the priests were very much urging me to go to Jesuit schools and so forth in New England, and I decided I wanted to go somewhere different, and God rest their souls, my parents let me go to Arizona State sight unseen. I had never seen the school. I went and stayed there and graduated from ASU in 1974, but I had my car packed with the last exam and literally walked out the door, got in my car, and drove back to Baltimore because that's where I wanted to live. And I had been admitted to the University of Maryland Law School, and I went to the University of Maryland Law School.
When did you first think about going to law school?
Well, it was an option I was considering. As a teenager, I went to work for PPG Industries, and as a very good job. I was in sales service for PPG. It was not a typical teenager job. And I had had conversations with people at PPG about my future, and they actually made me a very nice job offer out of college. But decided that I thought maybe law was where I wanted to go, and I went to the University of Maryland Law School.
Did you have a sort of mentor who steered you there, or was this just something right out of the blue?
No, not really. Although I very much, we should chat. A mutual friend, Tom Wilson, very much became a mentor to me, really beginning in my second year of law school. But up until that point, no, it was just let's see, and went to the University of Maryland, and candidly wasn't very interested in the types of courses I was taking in the first year. In the second year, the best things that happened were I actually took Antitrust my first semester of second year of law school.
Who was teaching it? Do you remember?
Well, Bill Reynolds was teaching it, and it was very interesting that what became available at the beginning was a clerkship at the Antitrust Division of the Maryland Attorney General's office.
Now, how did that become available?
It was just posted on the board. And I saw it, and I went to a professor who I knew well. It was not Bill Reynolds, another professor at the law school. And I went down, and I had an interview with Tom Wilson and another person at Charlie Monk at the Maryland Attorney General's office. And they had a TBA case that they needed.
You're going to have to explain what a TBA case is. Not to me, but...
Well, in the 70s, there were a number of cases involving tires, batteries, and accessories. And the whole issue was the oil company, supplier, franchisor of the retail service station dealer forcing through either a tying arrangement or some other arrangement the dealer to carry certain tires, batteries, and accessories of either a third-party supplier or maybe even branded by the oil company. And the state of Maryland, Tom Wilson had brought a case against City Service Oil Company and Goodyear, a basic TBA tying case. What was interesting about it was, first of all, what got litigated was the right of a state attorney general to sue in that arena under Section 16 of the Clayton Act. While there was Georgia versus Pennsylvania Railroad, this didn't fit necessarily the mold of Georgia versus Pennsylvania Railroad, so we had to litigate. And as a second-year law student, I was very much involved in the research of the origins of parens patriae standing for injunctive relief.
Wow.
For state attorneys general, working up to Georgia versus Pennsylvania Railroad.
Now, your boss at that time was Tom Wilson?
Tom Wilson.
Was he the head of Antitrust in the Maryland Attorney
Yes.
General's office?
Yes, he was. And Tom very much became a friend and a mentor to me because over time, Tom very much encouraged me to remain in antitrust. He pretty much the best piece of advice that I think Tom gave me, and although we continue to be very close friends, and sometimes I say to him, you know, my good days I thank you, Tom, and I curse you on my bad days, because he said to me that going forward in law school, as I went to electives, that I should choose my electives with the idea of how would that course help me in becoming an antitrust lawyer. Okay. And so, for example, I took a course on injunctions, which we spent weeks, believe it or not, on the Swift case and the consent order in Swift back in the 20s, in studying about consent orders and so forth. I took a counseling and negotiation class, and my project was how you negotiate a consent order with a government agency, and from both sides, which provisions are important. These were papers that I did in law school. And then the last one I did was whether NFL teams requiring season ticket holders to buy preseason tickets was an illegal tying arrangement.
I remember that dispute going way back.
Remember that?
You did that in Maryland, huh?
Well, I did a paper. We didn't do the case because we quickly realized it was only one product. Is there any difference between a preseason game and a regular season game? They were just making you buy more tickets. It wasn't really a tie-in. But in law school, at Tom's advice, and he very much was a mentor and again continues to be a very close friend, was to gear school and my studies to the best I could. Obviously not every course, but to becoming an antitrust lawyer.
Well, what happened after you graduated from law school? Did you go right to the Attorney General's office?
I never left. In that I actually had a judicial clerkship interview, and somebody went into Tom and said, you know, you better take care of this, because he had a judicial clerkship interview today, and he came in and he said, I promise you I will get you a job. And Tom went, and there was no budgeted position. And at the time, Maryland and the states had received funding because in 1976, Congress had appropriated $30 million, actually only about $22 million actually was paid, to jumpstart state antitrust enforcement. And Maryland, I don't remember how much money, but Maryland had received its share of this $22 million.
Why didn't the federal government put their hot little hands on that money?
Well, but you're looking at it from a 2007 perspective and not a 1976 perspective. What happened was, I think it was Tom Kuiper, I think was head of the Antitrust Division, and I believe Lou Engman was chairman at the Federal Trade Commission, actually had gone to Congress, which was going to give both the Antitrust Division and the Commission more money, and they both remarkably testified that they didn't need any more money. And the state AGs, never missing an opportunity for a buck, stepped forward and said, we'll take it.
Okay.
And it was also, remember, in the era, so it's a combination of the money, but it's also when Section 4C of the Clayton Act is enacted as part of the Hart-Scott-Rodino Act. Now, we all think of the reporting in terms of the amendment to Section 7 and 7A of the Clayton Act, but a very important part of Hart-Scott-Rodino was the addition of Section 4C of the Clayton Act, which gives state attorneys general the right to represent consumers in federal court in a class action type setting, but as an irrebuttably classified or whatever approved representative, certified class representative. And in fact, in my first year as a lawyer, and actually it's interesting, it's a 78 case reported in 1988. Can't explain why, but I got a court to rule that 4C actions are superior to Rule 23 actions, such that you can essentially, a state attorney general can displace a Rule 23 plaintiff. And Tom and I worked on that together. And so that money, Tom was able to get me a position.
And how long did you hold that position? At some point, you replaced Tom.
Well, actually, there was someone between me and Tom.
What was the sequence of events there?
Well, Tom went into private practice, I think in early 1979. I graduated from law school in 1977, so about a year and a half later, Tom went into private practice. A fellow by the name of Charlie Monk became the chief. He was then promoted, and I became the division chief in 1984. Most of the time, I had spent doing one case. I did a case, it's known as In re Mid-Atlantic Toyota Antitrust litigation.
I remember it well.
And I was the lead counsel in that case. I essentially did that case for alone, in the sense of the only case, I did for 4 years. And after that, I was about ready to do something more, and I became the division chief.
Well, that was kind of the major parents case of its time, wasn't it?
Oh, absolutely. It was a multi-state parents case. And the thing I'm proudest of about that case is that we had 37,000 consumers who we represented. We settled the case for the consumer had the option of taking a check for $135 or using it for additional service, could have bought service. And we returned checks to 92% of the people we represented. These people were from 1979, and we distributed those checks in 1984. And I was probably the proudest thing I had coming out of that case. And there was, as you know, there are 6 or 7 reported decisions coming out of that case. It was a very hard litigated case, but that we were able to get that money back to the consumers. Now, it was helped a lot because it was cars, and you have to update your address because of registrations. But even so, even working with the military, because we had a lot of military personnel, especially in Virginia and Maryland, we were able, 92% got checks, not some coupon.
Not coupons, right.
Got a check.
I remember you telling me about this at one point when we were sitting on the other side of the table. Let me digress for a second, Michael, and ask you, are you married by this time? I'm not talking about now. I'm talking about back then when you became the chief.
Well, let me tell you. I became married, my wife and I, we married in October 1984. The Mid-Atlantic Toyota case finalized in 1984, and we had our first child in July 1985, and I will tell you that I think all but one of the lawyers on the state side, they were in those days men, obviously we now have many more women, which is just terrific, but fathered children. 8 of the 9 fathered children in that 1 year.
Wonder if there's a lesson there.
That is a true story. It shows you how dedicated we were to prosecuting that case.
Yeah.
But anyway.
That's great.
My wife, actually I had met my wife in the Attorney General's office, and she's actually has left and gone back. She's still there doing criminal appeals. So we had a daughter in 1985 who is graduating this year with a degree in economics from the University of Virginia.
Terrific.
We're great. Very proud of her.
You ought to be. That's just great. Now, you mentioned that was a multi-state case. You were sort of present at the creation in the multi-state task force. Now, when did that occur? I mean, when was that formed?
Well, the task force, its conception was in August 1982. And the reason it came about was that in the 1970s, the state AGs did have multi-state activities, but were pretty much driven by proprietary cases, that is, cases that the states were a plaintiff tagging along either Federal Trade Commission or Department of Justice prosecutions. And unfortunately, and I will say this, we want to try to be updated, unfortunately some states were represented by private counsel, and that will become important for me in a couple moments in this. Well, as a result of Illinois BRIC, that was a dramatic event for the states because most of these proprietary cases, the states were indirect purchasers. And so those cases dried up because of Illinois BRIC. Now there was the effort, as we all know, of states then going in and trying to get so-called Illinois BRIC repealers.
Right.
But the point was that at the multi-state level, the cases dried up, and there was a position called a multi-state coordinator, and it was a staff lawyer, but was really involved in reporting on these proprietary cases. Well, they had dried up. Mm-hmm. And so the question became, well, what should we do now? Now, going back to the federal funding that paid for my first position, it really did jumpstart a number of antitrust units in the states. We were developing expertise, and we felt that some cooperation, or more than some cooperation, was warranted. And so a group of us got together in Seattle. It was in conjunction with a training conference that the NAG, National Association of Attorneys General, has each year for staff lawyers. And we said, oh, let's do this. And we just did it. I mean, there was no decree from the attorneys general. It was a group of us and said, let's do it.
Who was in the group?
Well, I can only remember two others. John Ellis three others. John Ellis from Washington State, which you may have known. He had done some multi-state, because the West Coast states were doing some things, for example, what was it, MDL 150 or whatever it was. Right. They were very much involved in those petroleum cases. And I think a fellow by the name of Larry Evans from Florida, and I want to say maybe Alan Kovacs from Massachusetts. I'm a little less certain about Alan. But we decided to get together, and in the first couple years of it was really just sort of meeting periodically to try to exchange information and see what to do. But I can tell you from my own perspective, I thought it was an important endeavor, I think, for at least two reasons. Number one, I felt strongly then that only in the rarest case should a state attorney general use private counsel. I really felt that we, as government lawyers and as government entities, government lawyers should be doing the work. And unfortunately, some states had used private lawyers on contingency fee arrangements that I felt really brought some of the wrong incentives to cases. Secondly, it was really one where I had really become committed to antitrust enforcement, felt it was important. I was not in agreement with the direction that I saw the federal agencies going in 1982. I obviously had utmost respect for Bill Baxter and Jim Miller. That's not the issue. It's just I disagree with some of the things that Bill and Jim were doing, and felt that we could present an alternative. And then finally, it was some of us had expertise. I had, well, not then, but I eventually had 10 staff lawyers in the state of Maryland. A little state like mine, that's how committed we were, that I could bring expertise and resources to states that didn't have. And that was a little bit of the Mid-Atlantic experience, Toyota experience, because we really were the ones that had the resources.
Well, now you've hinted at an evolution of the multi-state task force. When did it evolve, and how did it evolve, and what did it evolve into?
Well, like I said, early on it was really mainly just sort of meeting periodically and having some conversation, but we really weren't going anywhere. And I would say to you, if there was one event that sparked the task force, and I want to say this was at Harvard, I'm not 100% certain of this, but we had our training conference, and Bill Baxter came to give a talk. And as you may recall, Bill had Bill had said that if he saw cases, private plaintiff cases or otherwise, that he felt involved bad antitrust policy or was going to make bad antitrust law, that he would have the antitrust division seek to intervene as an amicus to present a position, whatever that may be, to the court. And Bill said that to us in a closed meeting I think it was at Harvard. And Lloyd Constantine, my good friend Lloyd, who had come on board in New York. And, we knew Lloyd. But Lloyd was sort of, I'll never forget this, was sort of up in the cheap seats somewhere. And next thing I know, Lloyd just challenged him. I mean, it was just vocal. And you and I know Lloyd, and, again, I have the utmost respect for Lloyd. And Lloyd just challenged Bill and just said, go ahead, do it. I mean, that was, well, those weren't the words. That was basically it. Go ahead.
Sort of a make my day.
Yeah, it was sort of, right, make my day, okay? Mm-hmm. And the funny thing about it was when it was over, somebody had to have lunch with Bill. Okay? And so they were all sort of wondering what to do, and I said, okay, I don't care. So I was the one that got to take Bill to lunch that day. Mm-hmm. But that event sort of galvanized the group. And shortly thereafter, Lloyd became chair of the task force. And
was he the first chair?
No, actually John Ellis
was the first chair.
John Ellis was the first chair.
Mm-hmm.
But again, it was Ellis, then Alan Kovacs. Lloyd, I think, was the third chair. But again, when John and Alan had it, we really didn't do anything. And not their fault. It was just sort of the early days of the event. But Lloyd brought an energy and a brashness to it to say, come on, let's do it. Okay? But our first multi-state case came to me. And
what was that one?
It's the resale price maintenance case, the Tva case. Mm-hmm. And a fellow who is, again, continues to be a very good friend of mine, Alan Mulaski. Alan was at Aaron Fox. And a personal friend of his had brought him a case. It was a resale price maintenance case involving the Maxim camera. And Minolta wanted it sold at $319.95. And I hope I'm not telling, I guess it's so old I can tell some of this.
Of course.
Is that Alan wanted to bring the case, and Aaron Fox would not allow him to bring it on a contingency basis. And I had cases with Aaron Fox, which, by the way, great little story. Sideline for a moment. We disagreed with the states that we said that states should not practice for a profit. And in our first 4C case, the Montgomery County Antitrust litigation, it was a follow-up on United States versus Jack Foley. We petitioned for $28.25 an hour for our attorney's fees. And a lawyer at Aaron Fox, Jim Mercurio, I love this story, I'll never forget, he started to get up from the counsel table. He put his hands on the table. And the judge looked down and said to him, Mr. Mercurio, you're not going to honestly stand up and object to a fee petition of $28.25 an hour. So you'll know my first fee was $28.25, and I was worth every dollar of it. But the point was that Jim Mercurio referred Alan to me. And he met me at night. He came over to Baltimore at night. He had everything but the complaint drafted. He had witness statements. I had this case. And like many of these cases, they had started out as a Colgate case.
Right.
And while the law firm eventually, Paul Victor, and this is how I got to know Paul, took over the case. Paul was not the original lawyer in the case. Wild Gottschall and Paul were not the original lawyers. Had given solid Colgate advice, which was nice on paper, but not implemented very well, because when Alan's client, that went out of business years later, but when Alan's client broke the price, the salesperson from Minolta said, but we had an agreement you would hold the price.
Right.
Well, here I had this case, all right? Well, and the federal agencies were not prosecuting resale price maintenance cases, and this is not the time to debate resale price maintenance. And I called Lloyd, and I said, I've got one. And Lloyd and I decided to do this case together. And we got 35 states to join in. By that time, Minolta hired Paul Victor and Jeffrey Kessler, and that's how I know Paul and Jeffrey. Mm-hmm. And we eventually settled that case.
Do you remember what the settlement was?
There was a settlement it was about an $8 million settlement. And again, going back to my insistence that there not be coupons, because I had coupons in Montgomery County real estate. And believe it or not, I was on a Washington area talk show, and I got grilled by these people criticizing me because they got this worthless coupon while the lawyers got all the money, okay? I got my $28.25 an hour. But in any event, I was not going to take coupons again. And so it was $8 million, but there was a claims procedure that people would get cash. The percentage was obviously nowhere near the Mid-Atlantic percentage. And I don't know what the percentage was, but it was an $8 million. I don't recall. There was money to the states. I don't recall what that was.
Well, that was the first of many of the state resale price maintenance cases. Do you remember any others that occurred over the years? I remember you and I went to war on one of them once.
Was that was Mitsubishi with Mitsubishi. Dick
Whiting?
Exactly right. It was you and Dick Whiting on Mitsubishi. And actually, I actually talk, while I don't mention Mitsubishi in that case, I use Mitsubishi now in some of my compliance talks because one of the issues that we felt was an issue there was my recollection that there were some restrictions actually on the price tag where it got down to the item on the floor, and don't want to get into the analysis of much years later, the CD case, whatever. But that's right. We had the Mitsubishi case.
You had Nintendo?
Nintendo, the way we got Nintendo. Mitsubishi, I can't recall how we got Mitsubishi. Nintendo, I got it because a partner, believe it or not, a former partner of Piper and Marbury, which is where I went to private practice, called me because he had been at a midnight sale at a toy store. And he's going through, and the cashier said to him that whatever discount was being given at midnight for buying these toys, they couldn't give the discount on the Nintendo games because Nintendo would not allow them to discount the product.
Right.
And that's how we got the Nintendo complaint.
Mm-hmm.
Well, what happened was that because the agencies, the FTC and the DOJ, had pretty much, of course, had gotten out of the resale price maintenance game. And let's not forget that Cuisinarts was prosecuted criminally, and the origins of Mid-Atlantic Toyota antitrust litigation was the Justice Department, and the man has passed away, actually was looking to indict an individual in a resale price maintenance case. Believe it or not.
Hard to believe today,
isn't it? Mm-hmm. And we ended up doing that case civilly and as a horizontal case, not as a vertical case. Mm-hmm. But my point is that the state AGs took up the mantle and were willing to do vertical cases. Now, in my view, without regard to, we can debate the economics and of resale price maintenance and what should be its position under the law. But for purposes of Section 4C of the Clayton Act and state enforcement, when you're talking about a consumer product and something where the consumer is being impacted by an overcharge, again, we can always debate whether there's an overcharge, I felt very strongly that that was a very appropriate case for state enforcement. Lloyd and I worked very closely together to the point where we cross-deputized lawyers. I was cross-deputized for an investigation in New York where I would go to New York one day a week and I would work in the New York AG's office. That's how closely Lloyd and I worked. We were, as you know, Lloyd and I were very, very close. We're very different personalities, but we worked very close. I had the utmost respect for him, and I would hope Lloyd of me.
Absolutely.
And we worked very closely.
Let me ask you, when did you become active in the ABA antitrust section?
I became active in the early 80s, and it was really at the time where I sort of emerged from being more local in nature in the sense of my work and really started to be interested in the broader issues that the ABA presented. I mean, I was moving from just prosecuting cases to becoming interested in the development of the law, policy, and so forth. And I felt that the ABA gave me the opportunity both to learn, but also as a young lawyer, the opportunity to participate in projects. And it's like any other organization. They're always looking for people to do things. And it's not an advertisement, but it was like, okay, I'd like to do that.
What section were you, or I'm sorry, what committee were you active in first?
I was really active in the state committee first, and I was also active in the Section 1 committee. But a lot of it actually tended to be more with respect to the state enforcement, because remember, when this is happening now, the mid-'80s, this is something new.
Right.
We have the beginnings of the task force. And the ABA obviously is taking note of Minolta and some of the early things that we're doing. And one thing that happened that was very important was that the lawyers we started to see were different. In other words, no longer was it the day, gee, I want to go hire that politically influential lawyer in some state. No, we start seeing you, Tom, or we start seeing Paul Victor, or Irv Scher, or Harry Reasoner. I could go down a list of just very fine antitrust lawyers that companies were representing. You all got to know us through the ABA, and you were coming in to see us pretty much the same, I would like to say, as if you were going in to see a staff lawyer at the DOJ and the FTC.
I think that's pretty much accurate. Let me ask you this, Michael. My recollection is that you were the first state AG antitrust to appear at the Friday program with the FTC chairman and the DOJ Assistant Attorney General. Am I right in my recollection?
Yes, and Tom, it really was the highlight of my professional career. The ABA had begun to bring the states as an entity more into the organization. I want to say maybe a year or two before that, a state AG position on the council had been created to be the same as the head of the Antitrust Division and the chairman of the FTC. And through that position, Lloyd had it and then I had it, we tried to get state AAGs involved in the ABA. In fact, I saw the ABA as one of my responsibilities as task force chair. Mm-hmm. And so, yes, I did that. It was a highlight. And recall that my promise, you were the head of my panel, and recall that the commitment I made to you, which was I would not refuse a question.
I think you didn't either. You didn't duck them, Michael.
You could have asked me any question you wanted. You may not have liked my answer, and I hope that I set a trend.
Well, you sure did. It was an excellent program. Let me sort of fast forward and ask you, when did you leave then the Maryland AG's office, and can you kind of bring us up to date as to what you have done since then?
Sure. Well, after our daughter in 1985, we had a son in 1987, and we then had another daughter in March 1990.
It was time to go to work. Outside,
as
right?
my wife said, I came home one day because I will tell you, at the end, probably less than half of my work was for the state of Maryland. Mm-hmm. And I came home one day and she said, it's time to stop having fun now. And, and I had an offer from Piper & Marbury about 6 weeks thereafter. And I went to Piper & Marbury, a very, very fine Baltimore firm, which has grown to become DLA Piper. And I continued my practice and very much my involvement in the ABA when I went to Piper & Marbury in 1990. Last April, almost a year ago, I left what is now DLA Piper. DLA Piper has grown to be 3,200. I had tremendous support.
Largest law firm in the world.
It is, and I want to say it's very, I had the utmost support by the senior management of the firm, but as you can imagine, a firm of that size, conflicts became very much an issue and so forth. And I've become very interested in the overlay of intellectual property and antitrust. And I have joined an intellectual property firm in New York, where I practice several days in New York, several days in Washington. one day at home, because I teach antitrust now at the University of Maryland Law School, and I would say about 60 to 70% of my practice is now antitrust intellectual property. It has been intellectually as challenging as I could find as a position. What is, of course, very current right now is the antitrust issues arising out of Hatch-Waxman cases.
Yes.
I am involved in north of 15 Hatch-Waxman cases. Very much now involved in Walker process. For those of you, it's fraud on the patent office,
Right.
Or sham litigation. And I'm very much energized by dealing with the issues. Of course, the agencies have just released the report on intellectual property and antitrust, which I'm reading. And so I am now at a firm by the name of Fromer, Lawrence, and Haug. And it's very, very interesting.
I'll bet it is. Let me ask you, who do you think is the biggest character that you've run into in the antitrust area in all these years of your practice?
Oh, it's Lloyd. And I mean that in a very, very good way.
Mm-hmm.
Again,
You're talking Lloyd Constantine.
I'm
now,
sorry,
right?
yes. In the sense that he had absolutely a brashness and an intelligence and an energy to it that, again, I thought was very important. You know, it's when you say characters, because I can tell you in my practice, I've been very blessed, and I very much respect when my adversary is a very good lawyer. In the antitrust bar, you have just tremendous lawyers. And so characters, Lloyd, great lawyers, there are a tremendous, yourself and Jim Rill and others that I've dealt with have just been great lawyers.
Well, I can tell you it's been a great pleasure to talk with you. I wish we could go on and on.
Oh, we could. But again, as I said before, I thank you very much for taking the time with me. It's my honor that you've done this.
All right, my friend.